I will now turn the presentation over to our presenter. You may begin.
Hi, everybody. Thanks for joining us. My name is Anna Shields. For those of you who don't know me, I'm a partner here at Jackson Lewis. And I'm so excited to spend the last Friday of this month and before a long weekend doing this webinar. And I'm very glad that you are all able to sign in and jump on. So I don't want to spend too much time with background and introduction. We want to jump right into the materials because we don't have a whole lot of time. And I think this is a really important topic today. And I think it's really critical that we try and focus on it as HR professionals, because this is where, as a litigator, I see so much litigation. It has to do with leaves as a reasonable accommodation, when they're appropriate, when they're required, when they're not required. And I think there's a lot of confusion over this topic. Very recently, so just a couple of weeks ago now, the EEOC issued new guidance called Employer Provided Leave and the Americans with Disabilities Act. And I think, you know, the guidance was maybe intended to be an effort to provide some clarity where there is not a lot of clarity in the law. And at least it provides clarity with respect to how the EEOC looks at these things. And I think for most of you all, this is probably a familiar issue. Certainly for a long time in New York, the rule has been that if someone needs a reasonable accommodation, one avenue of a potential reasonable accommodation may be an unpaid leave of absence. But we still see a lot of litigation over this, because here's the scenario that typically unfolds, okay? You have somebody working for you who qualifies for FMLA leave. They have some disability issue that requires them to be out. They go out for their 12 weeks of FMLA leave. 12 weeks is up. You have some kind of policy that allows them to apply for a, like a 30-day extension or some other hardline rule. And when the 30 days are up and they say, well, I can come back in 2 weeks, we say no, and we fire them because they've exhausted their time under the FMLA, they've exhausted their time under the policy, and many employers then forget to look at, I think, this third step, which is, all right, now that the FMLA is out of the picture, and now that our policies or collective bargaining agreements or other stuff is out of the picture, we still have to look to whether we should be granting additional leave to this person as a reasonable accommodation. And just like is the case with other reasonable accommodations, this turns on whether or not the leave would be unduly burdensome. And what often happens is by the time you've exhausted FMLA and employer-based policies, and then that person asks for the last 2 weeks, the department's fed up, they've been short-staffed for a long time, you get the feeling the employee's stringing you along, and there's like a knee-jerk reaction to say no, when in effect then the lawsuit is about those 2 weeks and nothing else. Because everything else you had to provide them under the law. So the only question is, could you grant 2 weeks of leave as a reasonable accommodation? And it's very hard to argue, no, 2 weeks would be totally unburdensome and not reasonable. And what the EEOC has come out and said is, look, these types of leave requests related to disabilities should be treated the same as other leave requests that are not related to disability. So think about a vacation. So in the type of fact scenario that I just described, if someone says I need those additional 2 weeks, yes, they've already been out for 24 weeks, but put that aside because that's what you were required to do under the FMLA or your policies, depending on how they're written. But these 2 weeks, I mean, you just granted their colleague a 2-week vacation when they got married. So why not give them 2 weeks for their disability? And the EEOC is saying you really have to look at it like that. The guidance that they just issued has some things that reiterate what I think most of us are already doing and most of us are already good at doing, which is ensuring that you get documentation from the employee. And look, many times that's a battle in and of itself, either because the doctor's not being particularly cooperative or because the employee is going to multiple doctors and not giving you clear guidance as to what they can and can't do. The idea behind today's presentation is to just really hammer home the point that in addition to the other potential reasonable accommodations that you might be able to provide to an employee, do not forget that leave, unpaid leave, is an accommodation. So I'll give you another example. You have an employee who, you have your written job description. It hopefully identifies which functions of the position are the essential functions of the position. The employee says to you, I can't perform the essential functions of the position for the next month. And you say, well, you can't perform the essential functions of the position. Is there any accommodation we could do to help you be able to do those functions? The answer might very well be no, not at least for the next 30 days. And so does that mean that there's no reasonable accommodation that can be granted? No. It means that there's no reasonable accommodation that can have them actually perform those essential functions in the next 30 days. But what the EEOC is saying, remember, there's an additional reasonable accommodation here, and that is, can you provide the employee with 30 days of unpaid leave with job protection so that they come back in 30 days and now they can do their job? And I'm using 30 days as just an example, all right, as what might be considered a reasonable accommodation depending on the facts of the case, all right? So keep that in mind. It certainly doesn't suggest anything about this leave being paid. It's an unpaid leave. It's really just a mechanism to allow an employee to go out, get better, and return to work and be able to perform the essential functions of their position, hopefully, after their return. The EEOC's guidance emphasizes something that I know we emphasize a lot, which is communication. You have to communicate very clearly with employees at every step of the process. They want you communicating with employees before the leave, so that's that discussion to say, hey, here's the essential functions, what can you do, what can't you do? If the answer is I can't do it at all, then the question is, when do you think you might be able to do this stuff with an accommodation or without one? But communicating is critical. Documenting that discussion is critical because they will say, we never had that discussion if you let them. You want to document the fact that you had the discussion so that, look, if an EEOC charge is filed or if a litigation is filed, we can say, no, before we put them out on a leave, we had a discussion with them. They said they couldn't come back, they couldn't perform these jobs, whatever it might have been. It's nice to be able to say to the EEOC, here's my memo to the file documenting the conversation that I had, okay? They want you to communicate during the leave, but not over-communicate. So you can, as an employer, reach out to check in as to the status of the employer's progress. What you can't do is require that they get back to you periodically. So you can't, in a policy, for example, say, hey, if you're on an unpaid leave, you have to get back to me every Friday as to the status of your leave. The EEOC has taken the position that's really unnecessary. If they've told you it's going to be 30 days, why do I need to get back to you in the process? Assume it's 30 days unless you hear from me. Otherwise, if you have reason to think that it's going to be different, you should just reach out to the employee and check in, which, look, that's usually appreciated anyway. Document those efforts. Many employers for a long time had what we call these maximum leave policies. So they say things like, we'll provide a reasonable accommodation and you may qualify for FMLA, and after FMLA expires, you can provide for an additional leave, but in no event can that additional leave last more than 60 days, as an example. That's a maximum leave policy, all right? And the EEOC has taken the position that, look, having a policy like that is not in and of itself unlawful. However, if an employee needs a reasonable accommodation to that policy, you got to give it. So if that 60 days expires and they say, I need another 2 days as a reasonable accommodation, you cannot say, no, I'm not giving you the additional 2 days because our policy says 60 days. And you've already used your 60 days. The EEOC is saying, look, you really want to stay away from these rigid policies. Modify, if you have form letters that you send out to employees requiring them to return by X date or else, modify those policies and modify those letters to make sure that you're allowing for this concept of providing additional unpaid leave as a reasonable accommodation. You're not guaranteeing anybody anything, right? That's the other critical thing here is what is a reasonable accommodation. And just like with any reasonable accommodation discussion, that is going to be wholly dependent on any number of factors. What the job is, who you are as an employer, Meaning how many employees you have, how much money you have, how many people are in that same position who can cover for this employee, or is it going to be totally unduly burdensome to hold this position open? That will depend on the job and the employer, and there's not a one-size-fits-all answer, and the EEOC seems to be recognizing that. When the employee is ready to return to work, you should engage them in a second discussion about what they can and cannot do with a reasonable accommodation. You should not say to them, I don't want you coming back until you're 100% recovered and ready to do your job. That's the wrong answer, because they might very well be able to come back and do the essential functions of their position with some other accommodation, like maybe someone will help them lift things or something like that periodically. So you're not going to know what's reasonable or what's possible until you have that discussion with the employee. So what the EEOC's guidance is encouraging you as employers to do is to communicate with your employees, again, emphasizing that communication to make sure that you understand what their capabilities are, and by all means, get doctors signing off on this, get the documentation, what their capabilities are, and what you can do that's reasonable or that isn't reasonable to try and accommodate them and work with them through the process so that when they have returned to work from their leave, they may still have some other reasonable accommodation in place for some time. The EEOC has tried to identify factors that at least it will consider, and courts look at a similar test of what they will consider in determining when an accommodation is reasonable as opposed to when a request for accommodation poses an undue hardship for you as the employer. And keep in mind the burden here, okay? If you're denying the request of an employee for an accommodation because it's unduly burdensome, it's your burden as the employer to come forward and explain why it's unduly burdensome. And these are the factors the EEOC has said it'll consider. Number one, obviously, being how much leave is required. Is someone asking for 6 years off, or are they asking for 2 weeks? The frequency of the leave, if it's intermittent. So, if this is someone who's going to be gone 4 to 5 days a week intermittently for 6 years, is that reasonable? Is there flexibility at all? With the intermittent leave, don't be afraid to get in that dialogue with the employee about what's reasonable and what isn't. Just because the employee has requested that they want, Fridays off to go to physical therapy, that doesn't mean you have to grant them Fridays. You want to grant them an accommodation that's reasonable, that allows them by all means to continue to work with you with their disability and work together to make that happen. But that doesn't mean that they get the reasonable accommodation of their choice. You can push back and say, hey, look, Friday we're always short-staffed. Is there any reason you can't go to therapy Thursday? The EEOC seems to be acknowledging this, all right? You can look at the impact that their leave request is having on their coworkers and whether job duties are getting done. So, again, this is one of those case-by-case analyses, which tends to run against what I think we typically want to do as HR professionals. We always want to say, well, look, here's what our policy says, and here's what we've done in the past, and when other employees have requested 6 weeks, we said no. Very, very different in an employment, in a disability accommodation context, because whether or not the accommodation is reasonable is so dependent upon the job, the staffing levels at the time. Look, by all means, there are certain jobs in certain departments where you cannot live without somebody for 10 weeks. There are other jobs in other departments where there's 100 people who have the same job and they can easily fill in, or you can get a temp to fill in. The EEOC is really just saying, these are the factors we're going to consider, and we want you as HR professionals to be evaluating these things on a case-by-case basis, and you should document your analysis so that down the road you can show the EEOC, no, we looked at this and we saw that here's what they were asking for, and either here's why we granted this accommodation or here's why we couldn't grant one. But you want to make sure that your decisions are supportable. One question that comes up a lot is, can an employer deny a request for leave when an employee cannot provide a fixed date of return? Okay, so in other words, if someone is asking for an indefinite leave of absence, do we have to grant it? And this is the way it comes about. The employee says, look, I don't know when I'm going to be able to come back. I can't work right now. My doctor's saying I'm going to be out at least for the next 30 days, and then they're going to reevaluate me. That's what you see. So the question is, look, is that an indefinite leave request? Because frankly, in 30 days, you might learn he's going to be out for a year. You don't know. The EEOC has said, if the employee can give you a definite date, a range of date, or some projected date, that's probably not going to be in and of itself an undue hardship or a reason not to grant the leave. However, if they say to you, I don't know when I can return to work, if at all, that is an indefinite leave request. And even the EEOC is acknowledging there's no accommodation that needs to be provided to somebody who has an indefinite leave request. You cannot reasonably hold a position open indefinitely. Okay, and so that sometimes is the window when you have, a difficult situation that you're trying to separate in a positive way. This might be an avenue for doing that. Okay, but take caution, because that's certainly the case under federal law. And here's an example. There's a recent case from the Second Circuit, which is what we're in New York. It's the highest appeal court in New York under federal law. You had an employee suffering from generalized anxiety disorder and panic disorder. More and more of our employees are suffering from this. All right, they said they'd be out for between a few weeks and several weeks. It was very vague. And basically, the employer had an indefinite leave request, and the Second Circuit agreed. Okay. Take caution, because the rule is not always the same at the New York State law level or the New York City law level. There's a case that came down called Romanello in 2013, and there's been a bunch of cases following this that hold the same thing, all right? Because this issue really does get litigated a lot, so be careful if you're dealing with one of these, that it may very well lead to litigation. So I'm, again, putting another plug in for documentation here. Here, an employee was absent from work for 5 months. All right, the employer actually paid their leave, because that's what their policy said that they were going to do. So 5 months of paid leave. They sent the employee a letter saying, hey, look, your FMLA expired. We want to know when you're coming back, or are you abandoning your job? The employee's attorney wrote back and said, quote, he has been sick with an uncertain prognosis and a return to work date that is indeterminate at this time, end quote. So the employer terminated, because that was an indefinite leave request, all right? The employee sued under New York State law and New York City law, saying you didn't reasonably accommodate me. Under New York State law, the court held that, yes, indefinite leave is not a reasonable accommodation under state law. That's consistent with the EEOC's new guidance from May 9th of this year. However, under the New York City law, at least at summary judgment, the court said not so fast. It's not per se the rule that an indefinite leave request is unreasonable. There may be circumstances where an indefinite leave request is totally reasonable. It really depends on the case, and you as an employer have an affirmative obligation. It's your burden to prove that that request was unreasonable. So, again, using the example, if you picture like a huge employer, a call center maybe with hundreds of employees answering phones who have varying schedules throughout the day, is one person's indefinite request really so unduly burdensome to grant? Probably not. And that's the point. That's the position that New York City has taken. That is not currently the role in New York State. So for those of you in Long Island without operations in New York City, New York State still follows the federal rule. But I want you to be aware of the New York City rule, because the trend seems to be New York City doing this first, the state following, and then the federals. Okay, so just as much as there's a trend towards paid leave, we are seeing this trend towards more and more courts saying, hey, not so fast. The fact that it was an indefinite leave request doesn't in and of itself make it unreasonable. And there was a similar case recently in the Southern District of New York with a similar outcome, where basically after an employee was diagnosed with cancer, they started their FMLA leave. The FMLA paperwork said they weren't coming back until June 14th. The employer then granted a bunch of additional unpaid leave requests all the way until August 30th. And eventually, when they didn't come back on August 30th, the employer terminated. And they filed suit again under both the state law and the city law. And under the state law, The court agreed with the employer, granted summary judgment, and said that was indefinite. They kept dragging out the leave time, and they can only grant a reasonable request, and that wasn't reasonable. But under the New York City law, they said not so fast. This is not a summary judgment case, meaning this is a case that has to go to a jury to determine you as the employer have the burden of showing whether or not it was reasonable or not. All right, so the takeaway from today, folks, is really just remember when you're working with your employees to try and figure out what reasonable accommodation, if any, you can grant them. You need to add to your repertoire and list of possible accommodations a leave. It might be, well, you clearly can't do the job now, or you can't do it safely, but, you know, if it looks like you're going to be able to do it in 30 days, then, you know, we'll give you an unpaid leave for 30 days. And that's all. That's the message. That's what the EEOC is saying. Be very careful of these hard, definitive policies. If you have one of those policies that says, in no event will we grant leave later than X date, be very, very careful about those, and I strongly recommend revising them. Because they're dangerous, and as I said, that's where we see a lot of litigation, is where I think people intend to do the right thing and follow their policy, but they get themselves into trouble by not providing a reasonable accommodation in the process. And that's it. So thank you all for joining us on this Friday. I hope you all have a wonderful, wonderful Memorial Day weekend, and certainly feel free to give me a call or shoot me an email if you have any questions about today's presentation. Thanks. Take care.